in a renewed bail application, this court is called upon to determine if there are new facts in the personal circumstances of the accused which warrants reconsideration of your early decision to refuse accused bail. We submit, Your Worship, that there is a litany of case laws that specifically deals with renewed bail application, and there is no notable confusion in this regard. The case of State versus Peterson, my learned colleague has referred to this case, makes it clear that the new facts are facts that came to light post the failed bail application. And this should not be a reshuffling of old facts masqueraded as new. And bail on new facts is not intended to remedy the deficiencies in the failed bail application. The case of State versus Fermas, also referred to by my learned colleague, indicates that if those facts were available at the disposal of the bail applicant, there must be justification as to why those facts were not presented in the failed bail application. And this is simply so, Your Worship, so as to prevent an abuse of this process. The case of State versus Stander. This one is a 2008, Volume 1, SACR 491. It's a Cape High Court decision, which makes it clear that the facts must be new, and this is not an avenue to re-argue the failed bail application, not a remedy of the deficiencies encountered in the failed bail application. And this is the principles that apply in a process like the one we have before court. Our submission is that in the absence of the existence of demonstrable new facts, bail application on renewed facts should ordinarily fail. However, if the court were to find the existence of such facts, the court still has to consider the entire matrix of evidence adduced before in the failed bail application and adduced in the new bail application. And over and above that, the onus remains that the bail applicant must prove exceptional circumstances that in the interest of justice demands his release, and this as contemplated in Section 6011A of the Criminal Procedure Act. We have noted that the following facts were presented and argued by my learned friend that they constitute new facts and must be treated by this court as exceptional circumstances warranting the release of the accused on bail. The first one was the birth of a new child. Secondly, the need to continue with therapy or psychological treatment, whereby it was submitted in this regard that the bail applicant has already missed a scheduled appointment and such therapy wasn't provided since his incarceration. The third we have noted is the urgent need to attend to medical treatment to address the pain that is caused by a dislodged screw on his ankle, the treatment of which was not provided for in present facilities despite repeated calls for it. The fourth one is that the financial ruin following incarceration, which currently led to a potential eviction of his life partner, as well as the minor child, and the wrath of unemployment on his employees. The fifth that we have noted is the involvement of the learned senior magistrate during the application for the J50 warrant, and the fact that the learned senior magistrate sat on bail application to the prejudice of the bail applicant. And in this regard, it was adjusted and argued that the accused stood no chance of persuading the learned senior magistrate as to the weakness of the state case, as it already formed a view in the warrant application that there is a prima facie case. And now recently today, we made to understand that the fact that the state witness, the respondent's witness, did not testify that in itself also amounts to a new fact, and we'll revert to it later on. Your Worship, the bail applicant conceded during his bail application that point number 1 to number 4, as already mentioned above, insofar as his facts are concerned, that they are not new. In fact, he was very clear that those facts, either they were ventilated during the failed bail application and they were at his disposal when the failed bail application commenced. Therefore, with respect to Your Worship, we argue that it will be ill-advised if one had regard to the proceedings in the bail application to submit that they are new facts. Now, we address these points one at a time. With regards to the psychological and medical condition of the applicant, such we submit is not a new fact. These facts were noted and managed by his doctor prior to his incarceration. That is Dr. Chaba, Your Worship. That's his evidence. In fact, the dislodged screw, according to this good doctor, was that it was noted just a day or two before his incarceration. The good doctor on this aspect has indicated or testified that he was managing the pain experienced by the bail applicant with the so-called Schedule 5 pain medication, and for the psychological well-being of the applicant, he had already then referred the bail applicant to a psychologist. We submit then, Your Worship, on the face of it, this is not a new fact. The financial ruin is also not a new fact. Same was canvassed at length in the failed bail application and in the appeal. Your Worship, the courts have long recognized the misfortunes that follows a detained person. Similarly, they have recognized the hardships consequent thereto. In the Lehlogonolo versus the state case, which we argued in the failed bail application, it was stated that the detainee's inability to continue with his normal life and carry out his day-to-day personal and financial affairs is a sine qua non for and a consequence of detention. The court then said that is part and parcel of a natural consequence of detention. Your Worship, the birth of a new child and the potential eviction of the life partner, inclusive of this new child, is a factor that the court must consider in the full determination of where the interest of justice lie. This court, as argued by my learned colleague, is the upper guardian of the minor children, and all matters that affect the minor children, the rights must reign paramount. But the issue regarding detention of the accused in juxtaposition with the paramountcy principle was long decided by the courts, and we have already addressed this aspect in the failed bail application. The paramountcy principle does not prohibit the arrest and detention of a suspected criminal whose arrest may affect the interest of the child. Your Worship, the case of State versus Mangweni is already in our heads. In the failed bail application, the state, the Obinyeluba versus the state case is already in our heads. And as such, Your Worship, we submit that nothing turns on it. In any event, the interest of the child and the paramountcy principle would not prohibit, by any chance, the detention of the suspected criminal. The involvement of the senior magistrate in the J50 warrant and the prejudicial effect that such had on the accused when he sat for bail application. Your Worship, it is our view that the mere involvement of the senior magistrate in the warrant application per se does not impute bias and disqualify him from sitting on a subsequent bail application. In S versus Herbst, it's a 1999 Volume 1 South African Criminal Law Reports 491. It's the Witwatersrand High Court decision. It was held that the disqualification arises only if the magistrate has prejudged the issues. This is not the case of the applicant, nor it is his insinuation in these proceedings. Your Worship, it is tried law that judicial officers are strongly presumed to be impartial, and the test for their disqualification is reasonable apprehension of bias. The test for reasonable apprehension of bias is objective and not necessarily the accused subjective fears. The case of President of the Republic of South Africa versus Sarfu, and also the case of State versus Roberts. This is the Constitutional Court case and the Supreme Court decisions. They make this point clear. In any event, Your Worship, it is the applicant's case, it is not the applicant's case that the learned senior magistrate was biased. No, there exists objectively a reasonable apprehension of bias. Although this aspect may on the face of it appear to be new, it is our view that it fails as exceptional circumstance warranting the admission of the bail applicant on bail. And this leads us, Your Worship, to the points in limine that has been raised in these proceedings. If the averment or the suggestion that because there was prior involvement of the senior magistrate in the warrant application, that in itself disqualifies the senior magistrate to proceed with bail application, would submit with respect, Your Worship, that there is no evidence to judge objectively that the learned senior magistrate has prejudged the bail application or the issues before it. Now, if this is the point in limine, would submit that it be dismissed. The second point, Your Worship, that was raised also relates to the DPP decision to centralize cases for trial and for bail application. Your Worship, bail is not designed to provide the remedy that is being sought. That is to challenge the decision of the DPP. If the idea is to challenge the decision of the DPP, the parja review mechanisms or the legality review mechanisms may be the appropriate one. And as such, even this one ought to be rejected and be dismissed. We've already addressed the issue relating to the involvement of the senior magistrate. But Your Worship, it goes now to the issue of the fact that we did not call a witness to oppose the new facts. We've already stated, Your Worship, and supported by case laws, quoted by us and by my learned colleague, that a bail application on new facts, it's a process upon which new facts are presented for the court to re-look into the matter to decide where the interest of justice lie. Now, whether or not the respondent leads evidence, nothing turns on it, because the inquiry still remains. Are they new facts before court? If they are, is the test or the onus that rest on the bail applicant discharged? And the issue of whether or not the respondent replied is not there. But over and above that, that argument misses the point that in bail application of this nature, the court must look into the totality of all evidence. The evidence that was led in the failed bail application and the evidence that is led in this new bail application. And the suggestion that that is an opposed, it amounts to an opposed bail application is not here nor there. The Supreme Court of Appeal, in the case of State versus Matebula, makes it clear that until a prima facie case of the prosecution failing, there's no need for the state to rebut that evidence. If we did not believe that there is no new facts before this court, we had no obligation to rebut that. Now, the big point that my learned colleague concluded on is the fact that the court's witness testified to the fact that there are no complaints recorded in the complaints register. In fact, it puts it clear, as the witness testified, that that duty rested on the prison authorities. Now, what are we faced with here, Your Worship, is that assuming in the favor of the bail applicant that he lodged the complaints of ill health with the prison authorities, who in turn did not write and record the complaints in the register. And it's the same where my learned colleague for the applicant also sent a letter to the area commissioner, the secretary of the area commissioner, who in turn did not cascade that information down to the court's witness. We're dealing with systematic failures that exist in the prison authorities. But is bail application a mechanism to address the failures, the systematic failures of the prison authorities? We submit not, Your Worship. We refer the court to a case, State versus Van Wyk, and we have referred to this case in the failed bail application. State versus Van Wyk is a 2005, volume 1, SACR 41. This is the Supreme Court of Appeal judgment, where it was authoritatively stated that bail is not a remedy for the failures or the systematic failures of correctional services. Assuming that those failures exist, assuming that he had complained, is bail the remedy for that? And we submit not, Your Worship. Your Worship, just in conclusion, we submit, with all the facts that have been adduced, our view is that there are no new facts, and it's only on that aspect or on that ground that the bail this application should be dismissed. But if the court were to find that those are new facts, we submit they still fail on the second leg, that they are not exceptional, where in the interest of justice would permit his release, and therefore, Your Worship, that the applicant has still failed to discharge the honors on him.